Bakit klaro sa inyo na gusto nyong mapabilang doon sa listahan ng mga private prosecutors dito sa kaso ni VP Duterte? Bakit klaro sa inyo na gusto nyong tulungan ang prosecutors, ang public prosecutors?
I think because the arguments are so well. First of all, it is our duty to stand for what is right. It is our duty as lawyers to stand for justice. And we see that this whitewashing, we see that this burying of evidence, we see that this brazen violation of the Constitution and the principle of accountability is being violated.
Enzo Recto, kalaban ang katiwalian at kasinungalingan, kakampi sa katotohanan at kabutihan.
Ang kilalang batikang abogado na si Atty. Lorna Kapunan ay nagpahayag ng kanyang kahandaang sumali sa prosecution team ng Kamara. Layunin niyang tulungan ang mga prosecutor sa pag-uusig kay Sara Duterte. Ayon sa ilang ulat, tila may mabibigat na argumento at ebidensya na rin ang Kamara laban sa legal team ni Sara. Ano nga ba ang dahilan ni Atty. Kapunan sa kanyang desisyong ito? At ano ang kanyang mensahe para sa publiko, mga kabunyog? Panoorin po natin ang bahagi ng kanyang interview.
Thank you po. Attorney, kailan po ba kayo kinausap ng House Prosecution Team?
Marami po kaming mga lawyers, legal experts, kinukonsulta pag ang issue ay either very legal or technical. And that's what happened with legal and technical arguments, no? Which practicing lawyers like me are very ready to see where the flaws are. Kasi maraming misleading statements, yung articles, yung answer ad cautelam, na hindi naman talaga answer ad cautelam, no? Motion to dismiss yun, which is a prohibited pleading, incidentally, in impeachment proceedings.
So you cannot file a motion to dismiss when you are just being asked to answer to the articles of impeachment.
Yes, because under the Senate rules on impeachment, a motion to dismiss is a prohibited pleading. Ibig sabihin, hindi ka pwedeng mag-file ng motion to dismiss.
Sure.
So, ang ginawa ng defense ng VP Sara is they call it an answer ad cautelam. Ad cautelam means with caution. Because ayaw nila mag-submit sa jurisdiction ng impeachment court. So, dapat, pero ang laman nun, puro grounds for dismissal. No?
And that's not, acceptable dapat, no?
That's not acceptable. Pati yung prayer nila, gusto nilang mag-hearing on the affirmative defenses, no? Iba yun, no? Wala naman sa Senate rules on impeachment na pwede mag-hearing on affirmative defenses. Kung i-question nila yung issue of jurisdiction, then they should do it when their turn comes to present evidence.
Okay.
Hindi yung ngayon pa lamang.
Hindi yung ngayon pa lamang, no? Kasi klarong-klaro ang Senate rules of impeachment. Ang operative word dyan trial. Trial to convict or trial to acquit. Wala namang motion to dismiss hearing dyan.
Opo.
Pakipaliwanag nga po sa ating mga tagapanood, no, Attorney Lorna, itong ad cautelam nila with caution nga, pero sinasabi ninyo parang ikinubli yung motion to dismiss dito sa mga misleading statements na ito. Sa madalit sabi, ayaw nilang magkaroon ng trial, ayaw nilang magkaroon ng proseso para panagutin ang vice presidente or at least
patunayan
ang kanyang pagka-inosente kung yun man ang kanilang paniniwala.
Exactly, tamang-tama yung sinabi mo, Carmina. You hit the nail on its head, no? Because laging sinasabi ni VP Sara na they want to go to trial where they will present evidence. And now, inconsistent yung position niya kasi pag binasa natin yung answer ad cautelam niya, there is not a single piece of controverting evidence. Puro usual arguments, the usual arguments we've heard time and again, not only from from her, but from senator judges in the impeachment court, yung issue ng 1 year ban, no?
Yeah.
At saka yung issue ng walang crossover. Yun na naman ang arguments nila, no? So, parang rehash of all of these arguments being present that had been argued in the Senate impeachment court before it adjourned its session.
So dahil ganun ang basa nyo dito sa ad cautelam na pinasa nitong kampo ni Vice Presidente Sara Duterte, ano naman sa tingin ninyo ang karapat-dapat na maging aksyon ng Senado? Because as you said, it's very clear. The operative term is there has to be a trial.
Yun nga tatanungin ko sana, partner.
Oh.
Klaro ho ba talaga, Attorney Lorna, yung Senate rules, or are they making up rules as they go along?
And the Senate rules are very clear, no? If ito na nga ang nakakapagtaka, no? They're holding the House accountable for the rules of the House. When the rules of the House are very clear, no, sa 1 year ban, no? Pero sila naman, ang dami-dami nilang interpretation. First, they interpreted yung forthwith, maraming interpretation. Then now they're saying that despite their rules, the Senate has sole authority, which means that they can dismiss anytime they want to, which means that they don't need to go into trial. That is, to me, that is wrong. I don't want to sound disrespectful to the impeachment court, no, because regardless, we're all officers of the court, and the public prosecutors are officers of the impeachment court. But as officers of the impeachment court should by itself abide by its own rules, not invent them or amend them when it is convenient for them. Wala sa Senate rules na pwede silang mag-rule on a motion to dismiss. If at all, let that be the defense position when it presents its own evidence. Kasi may order of trial yan. Una, ang prosecution will present its evidence, and then pagtapos na yung turn ng prosecution, turn naman ng defense. Kung wala silang ebidensya or takot sila na mag-present ng ebidensya, i-argue nila yung motion to dismiss. But it must be in a full-blown trial.
Correct.
So ano po ang appropriate action coming from the Senate impeachment court with regard to this answer coming from the camp of Vice President Duterte?
To reject it?
I think the impeachment court, because together with the filing of the reply to the answer, humingi na rin ata ng hearing dates ang public prosecutor, no? Because under the Senate impeachment rules, the rules of court apply with the supplementary character. Ibig sabihin, meron dyan rule on judicial affidavits, meron lang rule on pretrial or marking of exhibits, merong rules on setting of the trial dates, no? So, consistent with the position of the public prosecutor, that there should be a hearing forthwith or trial forthwith, humingi na rin ata ng trial dates or humingi ng date where they can mark their voluminous evidence, no? Kasi sa dami ng ebidensya, kailangan ng pre-marking. Otherwise, hindi maintindihan ng watching public yung marking of exhibits, no?
Actually, ang sabi ni Senator Chisa Escudero, partner, if I remember correctly, bahala na ang 20th Congress, which actually begins today dahil ngayon uupo yung mga bagong halal na senador. Sila na ang magsiset ng mga pre-trial and trial dates. Tama ho ba, Attorney Lorna?
No, the public prosecutors entered already their appearance, no? Kasi one of the technical arguments being raised by either the spokesperson of the House or Senator Cheese is that nag-entry of appearance sa mga defense counsels, no? Again, appearance ad cautelam. Favorite word nila yung ad cautelam.
Okay.
And the argument put forth was compared to the public prosecutors of the House, ang entry of appearance ginawa sa Senate when the Senate had not yet convened as an impeachment court. So to forestall that legal technicality, nag-file ng entry of appearance ang public prosecutors sa impeachment court. In the 19th Congress.
Okay.
Ngayon, sa 20th Congress, because two of the 11 public prosecutors had got defeated in the elections, they have to be substituted.
Okay.
And that's what I think should be done in the 20th Congress.
Okay.
To elect substitute public prosecutors. And I think if the news is accurate, that would be Congresswoman-elect Laila
Correct.
Lima and Congressman-elect
Shell Jokno.
Shell
Yeah.
Jokno.
Attorney Lorna, balikan lang po natin. Bakit klaro sa inyo na gusto nyong mapabilang doon sa listahan ng mga private prosecutors dito sa kaso ni VP Duterte? Bakit klaro sa inyo na gusto nyong tulungan ang prosecutors, ang public prosecutors?
I think because the arguments are so well. First of all, it is our duty to stand for what is right. It is our duty as lawyers to stand for justice, and we see that this whitewashing, we see that this burying of evidence, we see that this brazen violation of the Constitution, and the principle of accountability is being violated. We cannot, as officers of the court, stand by and let this happen. And that is why ang dami-daming pong legal experts at volunteer lawyers and commentators who have said that we are willing to assist. We are willing to assist and give guidance in terms of our own years of expertise to the public prosecutors. That is to be, well, to quote a famous word, we have to be on the right side of history. And I think this is the right side of history.
And Attorney Lorna, I'm sure you've heard about what Senator Amy Marcos has said. Now, this is not about holding someone to account. This is all about 2028 and to diminish the rival in 2028. Anong sa tingin ninyo sa mga ganyang klaseng mga statement na tila bagang isinasantabi yung prosesong protektado ng konstitusyon at linalagyan lamang ng kulay politika?
I think the senator judges, Senator Amy and all of the senators already took their oath as senator judges. And part of the oath as senator judges is to adhere to the Constitution and to adhere to the proper rules in impeachment proceedings. Also, by the own Senate rules, it says so clearly that the senator judges should act with political neutrality. So I think it behooves them to refrain from giving comments on their own political biases unless and until they hear the evidence. Otherwise, they are prejudging the impeachment court. It is a betrayal of trust. It by itself is a betrayal of trust of the public that elected them into office. Remember, they're all senators. They have the mandate of the people. They have the mandate by law to be accountable. And being accountable, being senators and senator judges, I think part of being accountable is their duty to listen to the evidence. Because if they cannot, and if in their minds they have already prejudged the case, then there are also rules that say that they should recuse themselves or inhibit themselves. Kasi hindi pwedeng ang public prosecutors ang mag-file ng inhibition. It is up to the conscience and up to the good judgment of the senators who feel that they have already prejudged the case without seeing the evidence to just inhibit themselves.
So wala hong pwedeng maghain ng motion para mag-recuse yung mga supposedly biased senator judges. Kailangan inisyatibo mismo nung senador kung feeling niya ay nakompromiso na yung kanyang neutrality.
Yes po. The public prosecutors cannot file for inhibition.
I see. Okay.
Attorney Lorna, kanina nabanggit nyo na hintayin muna na makita ang ebidensya bago magsalita, no? Kayo po ba'y nakita nyo na ang ebidensya? And what can you say about it? Mabigat ba? Malakas ba ang ebidensya laban kay VP
Hindi
Duterte?
pa naman sub judice ito, no?
No, because the articles of impeachment, together with the attachments, with the attachments 30, are part of the Senate website.
Okay.
So we have seen the evidence submitted, which are annexes to the articles of impeachment. Apart from that, hindi ba almost daily telenovela ang mga Senate inquiry, ang congressional inquiry in aid of legislation, where they laid out all of this strong documentary evidence, none of which incidentally have been controverted by the Vice President. Sa answer, it is telling that in the answer, she has denied everything without putting forth why. She denied all the ultimate facts. Ang sabi niya sa motion to dismiss niya, answer ad cautelam, is wala naman daw basihan yung complaint, no? Yung articles, no? Because the prosecution did not state the ultimate facts. How can they say that when it is so evident that the charges there are buttressed, are supported by very clear and convincing evidence? And I say this as a practicing lawyer. I say this with no bias at all.
Okay.
But I say this because I have seen the evidence. I have seen the attachments to the articles, and I've heard the congressional hearings in aid of legislation.
Yeah.
What did she do? What did the Vice President do? She denied everything. Ang inadmit lang niya sa answer niya is yung personal circumstances niya. No? Yung pangalan niya, yung address niya, and yung her position as Vice President. In fact, when I thought about it, I think she should also deny her position as Vice President because she's not acting as such. She's going around in the last month. She has had 4 trips in the last month. What is she doing in these trips? She is going around trying to elicit support of our overseas Filipinos. She's going around attacking the government of which she is part of. She's going around betraying the public trust. In other words, she is already operating as if she styles herself as the designated survivor. And she is acting as such, as if there is no president, as if there is no cabinet, of which she must be a team. She is destroying the credibility of the administration, and she is destroying the trust of the people. How can that be the job description of a vice president? But she should deny that as well kung ayaw na niyang maging vice president.
Attorney, panghuling tanong na lamang po, kanina pinag-uusapan din namin kung yung po bang articles of impeachment, pinaghati-hatian nga po ba into different teams na sa pong mag-argue po nito sa impeachment trial? Ganun ho ba ang magiging proseso? There are different House prosecutors tackling specific articles of impeachment. At kaninong team po kayo kasali?
Ako naman self-proclaimed, no? Self-proclaimed assistant to all.
Assistant to all. Okay.
Alam mo naman tayo, di ba? You know my history.
Yes,
I am not one to keep silent.
Oh, yeah.
I am not one to keep my mouth shut when I call it the way I see it. So,
Assistant to all.
di ba, ganun yun. But from interviews of the public prosecutors, yes, it makes good sense. It makes good sense that public prosecutors are assigned specific articles because of the immensity of the testimonial and documentary evidence. That's the other thing na idadagdag ko lang. Siguro ayaw mag-trial ni VP because pag trial na yan, modes of discovery are allowed. Ano yung modes of discovery? Pwede magpasabpina ng bank records. And they cannot hide behind the bank secrecy laws because precisely impeachment proceedings and an order from an impeachment court is a clear exception to the bank secrecy laws. They cannot quash a subpoena requesting for the real names of these aliases and alleged confidential funds, no? Because may tao, kung totoo man na bona fide recipients yan ng mga awards or bona fide informants yan, then under the COA rules, the Office of the Vice President and the DepEd, or all government agencies that deals with confidential funds, should have a list in their vault of real
Actual
names,
identities.
of real people who receive. Pwedeng isabina yan. So, lalabas nga dyan kung meron nga bang Marian Rivera na tumanggap, meron bang Ontiveros na tumanggap, meron bang Piatos na tumanggap dyan. What are their real names?
Opo.
This can all be subpoenaed.
Yeah.
Even the interviews, her own interviews, where she talks about her own seditious interviews, can be subpoenaed. So all of these are being hidden under a motion to dismiss,
Opo.
where she refuses to submit to the jurisdiction of the court. Meron rin siyang sinasabi, nakapending na yan sa Supreme Court. That's one. Then she says, nakapending yan sa Ombudsman. Nakapending yan sa COA na naka-appeal kami sa COA. What are all of these things? All of these things are dilatory. Plus, if the Supreme Court has not issued an injunction for the impeachment court to proceed, nothing will stop the impeachment court.
Opo.
The rule is also sa ombudsman, a pending case in the ombudsman will not stop an impeachment court. A COA ruling, a pendency of an appeal with the COA will not stop an impeachment court. So all of this
All right.
are aimed to, sabi nga namin lawyers, to obfuscate,
Obfuscate.
Yeah.
to confuse all of us na hindi naman pwedeng i-confuse lahat. You cannot fool all the people all the time.
Opo.
Bunyog, bunyog, halikan na kasama ka. Bunyog, kapag buklod ay may pag-asa. Luzon, Visayas, Mindanao, isa ang pananaw. Sa bagong Pilipinas ang bunyog isisigaw.